It's a great honor to be amongst you. I see so many colleagues, and of course, I'm delighted to work again with my colleagues at the University of Massachusetts Amherst. This is very special to me because I started interpreting back in 1980 when I was fresh out of college at the Boston Superior Court. And back then, many of you probably know, there were no training programs. Testing was not really there. There were few, if any, interpreter associations. And look how far we have come in the space of, well, 40 years. In any case, I have to share with you a presentation today that it really addresses different levels of interpreters. So you'll bear with me because I'm going to start with just very quickly telling people how to get certified. And I know that many of you don't need that information, but it'll be very quick. And then I will go into deeper aspects of court interpreting. And I'll share with you a number of resources, which is really the main part of my presentation, resources that you can use in your daily work and also in your development in the profession. So I'm going to start by sharing screen, and I'm bringing up a couple of sites. Let's see. Okay. Are you seeing my document that says certification?
Yes.
Very well. All right. So basically, I just want to point you to two websites that are very useful for people who are wanting to enter the profession and get certified, and also for resources for interpreters in general. One thing that I will say is that you have the good fortune of having programs in Massachusetts like that of the University of Massachusetts at Amherst, which is one of the premier programs in the country. And you may or may not be surprised to know that there are many, many cities, important metropolitan cities, including Chicago and many other cities where it's very difficult to have access to interpreter training. So I would encourage you definitely to reach out, get the training at the university instead of just showing up cold to a rigorous exam, both the written and the oral in court interpreting. If you go prematurely without the proper training and practice, you may get discouraged, and that's not a good thing. You know, it's not good to be too soon or too late. So it's good to get the training, get the orientation, and then go for it. So the first website is the National Center for State Courts, which is ncsc.org. And by the way, through my presentation, feel free to take screenshots of whatever you like. That way you don't have to take notes or feel that you're going to miss something. So this is one. There's resources, there's practice exams, there's all sorts of information there for interpreters, the certification process in all the states. Now, specifically for Massachusetts, there's the Office of Language Access of the Massachusetts Trial Courts. And you might be familiar with this website, but here is really where you're going to find a lot of the local information that is pertinent to Massachusetts and to the certification process, as well as training and organizations and everything else. So I would encourage those of you who are in that path to explore these websites. Very well. Now I'm going to talk a little bit about, let's say that you have your first assignment. And, you know, again, I'm starting with little steps from the beginning, but it'll get in depth fairly soon. Nevertheless, the first thing that the interpreter needs to do is to get information about the case. Let's say that you are assigned the case or a mission, and they call you either from the language office or the interpreter's office or the clerk of courts. That varies from jurisdiction to jurisdiction, right? And we also know, those of us who have some experience in the courts, is that every courtroom has its own folklore, its own way of doing things, it's certain vocabulary sometimes, and in particular, the way that current judges like things done, you know, and that word gets around and it becomes part of the local folklore. And that's something that we learn on the job very quickly. Also, terminology is something that we learn on the job fairly quickly. Of course, one of the things that I'm going to encourage you to do is to keep a glossary or to augment your current glossary as we go through some of the materials that we have today. So the first thing I wanted to show you, let me see if I can share screen again. All right, can you see this list here that says public access to court records?
Yes.
All right. So this is a Google search. And look what happens. You just put in public access to court records and you get them here in Massachusetts, in different places, right? Now be careful when you follow these links, because you may get into some websites that are gonna want to like charge you a fee or something like that. And you wanna avoid registering, giving information, you know, all of those things. This is all information that should be freely available. Recently, I was involved in a case as an expert witness where there was an interpreter involved, and she had been assigned to another case about an hour later in another jurisdiction, and said, well, you know, my supervisor didn't tell me about this case not going any longer than whatever. In other words, she didn't have the information because the supervisor didn't send her the information, right? And, you know, I mean, it kind of is all right. I mean, the judge accepted it. But in reality, that interpreter, all she had to do was to go online and look up the case. And sometimes a simple Google search. But if not, just go through the public access court records and always look up the cases that come in. Don't rely on somebody else telling you or not telling you. Get the information firsthand if you can. So if they give you an assignment, the first thing that you're going to want to do is get the information. For example, the charging document, where it gives you the little bit of a rundown of the crime that was committed, how it was committed, who committed it, and so forth. So that way you have a background for what's going on. If that is not provided to you, then look it up online. This is another, let me share screen again. Massachusetts court records and so forth. So you're gonna see here that you have this website, instant access. You can search any case. This is specifically for Massachusetts. And then you have LexisNexis, where you can pretty much find anything. The downside is that you need to subscribe. So there's some interpreters who subscribe, lawyers, of course, do. If you use it regularly, it's worth it. Otherwise, there's other ways of acquiring the information without having to pay a fee. And finally, I have Pacer. And but Pacer is only for federal cases. So these are different ways in which you can look for a case, find out what it's about before you just go in cold. And sometimes you are a little bit lost in there. You don't know exactly what's going on. So that's as far as court records, how to obtain them. As much information as you can get beforehand, the better, okay? Now, I'd like to share with you this document. Let me see. Here we go. Entitled Criminal Procedure. This is kind of like a synopsis that I prepared for my classes, which runs you through these steps in the criminal process, right? First, investigations. There are pre and post-arrest investigations. And in many cases, they are conducted by the police department or the prosecutor's office, sometimes by the probation office. Rarely do they hire an interpreter for this. Many times they use bilingual officers and so forth. That leads to a set of problems in itself. But nevertheless, rarely is an interpreter contracted for that. The same for arrest, right? Now, the first appearance or arraignment, depending on where you are, is really when things begin to happen, right? They read the charges, they ask for a plea, they may assign an attorney. So it's basically the identification of the person. First of all, there's two things that are basic. Was a crime committed? And was this the person who committed it? So those are the two things that initiate the process. Then you have preliminary hearing. And here is sometimes this is like sometimes before the arraignment. And now this order may change from court to court. But here is really where I want to focus on, starting with pre-trial, and then we'll go into the trial, right? But the important thing about this is that, like it happened to me when I started, I would be called for a case. I would go in, and I knew nothing about the case, or just very minimal things about the case. But most importantly, I didn't know what step of the procedure we were at. So it was kind of like a discovery through trial and error. And that was difficult. So many times I felt a little bit lost. So the first thing is to see the progression of these steps in the criminal procedure. Now, after the arraignment, there's going to be a probable cause hearing to make sure, usually within 10 days of arraignment, to see if there's enough evidence to continue with the case, right? So these are all steps. And in preliminary hearings, the attorneys are going to talk about different aspects. There are pretrial procedures where they're going to make motions, where they're going to sometimes discuss with the judge and agree among the parties which instructions to the jury are going to be used if it's a jury trial, and so forth. But the main thing I wanted you to focus on, and if you want to take a snapshot or a screenshot, please go right ahead, is the different types of motions, and this should be a section of your glossary. I like to divide my glossary into sections and subsections, not just alphabetized like a dictionary. That way, when I'm preparing for a case, I go to the specific section and I read the words there, and I kind of like refresh my memory about those words and that semantic field, that field of content. And here you have some translations into Spanish next to it. Then there's a plea bargain, and it's always good to find documents. You can find them online, like a plea agreement, practice site translating a plea agreement, and things like that. So these are things that are documents that will help you, but that are also very good practice materials, so that when you do the actual case, you'll find it all a lot easier. The bail hearing, of course. And at each stage, there are different typical questions. There's different vocabulary that comes up. For example, in bail hearings, we want to know if there's a criminal record, if the person has roots in the community, if it's a person of good character, if there are character witnesses, a number of things like that. And that's the type of vocabulary that comes in. When we are impaneling the jury, it's surprising because sometimes the type of vocabulary that comes up is the different traits and occupations of people. So they have a number of set questions they ask potential jurors, and one of them is their occupation. And you're going to get all sorts of things, sometimes difficult to translate, like landscaper or caterer and things like that. And so those are typical things that happen during that stage of the proceedings, right? So sometimes it's a good idea to have at least a section of your glossary divided into these different steps and the typical vocabulary that tends to come up in each of these steps in criminal procedure, okay? Then, of course, we're going to get into the trial. After the jury selection, the jury is impaneled. They have 12 jurors and 2 alternates. And then they begin with opening statements. Now, I'm going to go back to opening statements in a minute, but quickly, I'm just going to run down these steps. And again, feel free to take a snapshot or a screenshot as we go along. After the opening statement, then comes a presentation of evidence. First is the prosecution, then the defense. They're going to call witnesses, testimonial evidence. There's tangible or demonstrable evidence. There's documentary evidence. And then there's objections. Now, here is also another interesting section that you may want to take a screenshot of and also add it to your glossary as a subsection. So here are different objections. Objections to question. You can see here the different ones, and I have a suggested Spanish translation next to them. Objections to answers and objections to exhibits. So notice that now we have 2 sets of vocabulary here that are really important. Motions, the different types of motions, and objections, the different types of objections. These are things that you need to have them prepared so that when they come up, you don't really have to search for words, but it should be almost instantaneous. And basically, this will carry you through a lot of the interaction in the court. Then the case rests, the prosecution, then the defense. There can be rebuttal arguments, then closing arguments or summation, final jury instructions, and so forth. Of course, we always kind of like memorize the oaths and all the vocabulary that tends to be formulaic. We kind of like prepare it and we kind of like get used to it ahead of time. All right, so now, after that quick overview, which is basically for you to be able to place yourself, you walk into a case cold, and quickly you have to figure out, okay, what stage am I on? But the main thing that I wanted to focus on, and I'm going to show you several manuals that are going to be very useful, is the trial itself. And the central thing that I want to focus on as far as the trial is what is called the theory of the case. The prosecution is going to have their own theory of the case, and the defense is going to have a different theory of the case, basically that my guy is innocent. Now, the theory of the case is absolutely key for us to know what each of the attorneys, whether it's the prosecutor or the defense attorney, what they're pursuing, what's behind their questions, okay? Now, how do we begin to figure out the theory of the case? Well, first of all, you probably know that it is outlined in opening statements, right? The prosecution makes the opening statement explaining why this person is guilty, what the evidence is going to show, and then the defense, if they choose to do so, makes their own opening statement, and they explain their version of events, what the evidence is going to show, and how their client was either not guilty or justified or has some kind of a powerful defense. And that's going to be the theory of the case. But all you're going to hear is a narrative, and it's difficult to extract what the actual theory is from there. In addition, the theory has particular elements. So the first thing we want to do is we want to go and see, I'm opening this file. We want to find a document online, or perhaps from a lawyer friend or at the law library or a public library, that is called Elements of Crimes, all right? Or Elements of Common Crimes. And here's one. Let me share the screen. All right. If you can see it there, Elements of Criminal Offenses. This one is from a different state, but they all tend to have the same types, the same elements, because these are very logical. They're almost like a theorem. For example, the charge of battery. Number one, the defendant caused bodily harm to another person. Number two, the defendant intended to cause bodily harm to the other person. So there's intention. Third, the defendant caused bodily harm without the consent of the other person. And the defendant, in other words, it wasn't a boxing match or a sport. The defendant knew that the other person did not consent. So those are the elements of this particular charge. So if you have the case, you know from the charging document what the charges are, you go first to elements of crimes and you look, okay, these are the elements that the prosecution is going to have to prove and that the defense is going to have to disprove. So this gives you already the roadmap of what the theory of the case is going to be. Let me look here at another one. This is a trial manual. Now, I just found this online. If you buy the book themselves, I mean, these are huge books. They're very expensive. They're like $200. But also many of these books, like they have new editions. And some of the old editions, sometimes if you know lawyers who have some old editions, they may just give them to you because they have the new one. And for our purposes, which is vocabulary and the elements of crimes don't really change, we don't need to have the last edition of anything. And we certainly don't want to be spending a couple $100 on manuals. You can find them online. Sometimes it takes a little bit of looking, but you can see, for example, American Law Institute, the different organizations that will publish them and present them online. Now, many of this, this is copyrighted material and so on and so forth. So whatever is freely accessible online is fair game. And of course, there's also a lot of organizations and state agencies that put up public documents as a public service, and they are free to use. So this trial manual is great because you don't have to read the whole thing. You just go specific, you go to the index or to the table of contents, and you see what part you're on, and you kind of like see this is what guides lawyers in terms of what happens, what to do, how to do it. And you go directly to the part that is pertinent to your case, right? Initial stages through arraignment. So you can see what I presented to you in abstract form. You can see it all detailed with explanations and so forth. It's also a good way of acquiring vocabulary. So in other words, you don't have to become a lawyer. You just have to find out a little bit about how lawyers work, okay? And see, now you have bail and you have the different elements of bail. So, it's good to just use these as reference materials. Case planning, developing a theory of the case. That is so important. And it's one of the things that that we need to keep in mind and try to figure out as a roadmap for the entire case. And then there's ways of presenting evidence. So again, these are very, very useful manuals that should be part of your arsenal. Here's another one. This is from Colorado. And it's practical guide for presenting evidence. There's the rules of evidence. That's another big manual that lawyers use. But that one is, has statutes and it is just too dense for our purposes. Whereas these are practical manuals that really take the lawyers and the interpreters by the hand, chapter by chapter. Let me get to the table of contents, and you'll see after we pass all these nice pictures of all these nice people. Here we go. Evidence, witnesses, how to establish the competency or lack of competency of witnesses, corroboration and support, identification, which is a very important thing, reputation, impeachment, and rehabilitation. Now, these sections will also have sample interrogatories where a prosecutor or defense attorney is asking a witness, is examining a witness specifically on these things. And there, when you read those things, you can see exactly what's behind the question, because it's just so clearly explained in these manuals. Now, impeachment is basically discrediting a witness. So first, the prosecution presents their case, and they're going to call prosecution witnesses. And they're going to, the prosecutor is going to go chronologically with very clear questions in order to establish the story and so on and so forth. But then in the cross-examination, the defense get to examine the prosecution's witness. Now the defense is going to jump from the past to the future to the present, back and forth, to not really try to confuse the witness, but to get him out of this memorized chronological story of events, to see if what they're saying really coincides, the different aspects of it with the different time frames and with other evidence in the case. So there are two very, very different styles of questioning that you're probably have become familiar with if you've listened to both sides interrogate a witness. Rehabilitation is to restore the credibility of the witness. So again, you're going to find here in these chapters sample interrogatories for many, many different things. Now, here, this is actually from Massachusetts, is something that I use. Is a manual. Now, this is it's a 1993 edition that a lawyer friend just gave to me, and it's excellent because it has everything we need. It's a practical guide to introducing evidence, and it has the sample interrogatories. Again, this is when there's a child witness. They have different types of witness. When somebody's just giving a lay opinion as opposed to an expert opinion, and so forth. How different types of witnesses are examined with samples, and so forth. And again, remember that each side is trying to prove the elements of the crime or the lack of the presence of those elements of the crime in the case of the defense. So you kind of start checking back and forth in your preparation between these different manuals, the trial manual, the evidence manual, the elements of crimes, and so forth. And then the final one is jury instructions. Let me go forward. Okay, here we go. There are instructions to the jury. This one, I believe, is from Florida, from the 11th Circuit. But in any case, each circuit will have their own, and it's usually freely available online as a public service. And here you go, preliminary instructions. So these are texts that are very good to practice, to do site translation with. That way you kind of like learn the vocabulary, but you also learn kind of like the logic of the law. It's all contained in jury instructions. So you really do learn a lot about the law and a lot about the cases and the whole trial procedure from reading the different jury instructions. So basically, if you have a particular case, battery, for example, like in the example that we saw earlier, you're going to look at the elements of the crime. You're going to see what evidence is presented, the opening statements, and so forth, and then follow along. But you're also going to go and shuttle to jury instructions. And that way, when they come up, you're going to be prepared. You can actually find the exact jury instructions that they're going to use, site translate them, prepare them, so when the judge imparts them to the jury, you're ready. And of course, we know that there are two modes that are used the most, consecutive and simultaneous in court. We also use site translation once in a while. An important thing is never site translate for the record. In other words, don't introduce evidence into the record that you're site translating from a document. That type of evidence should be translated in writing and then presented to both parties and admitted according to the rules of evidence and so on and so forth. Sometimes judges don't know this and they give you a piece of paper and they want you to site translate it for the record. And you should not do that. You should say, no, this needs to be translated in writing, Your Honor, and so forth. But you can site translate things like a plea agreement to the defendant who's pleading guilty. So you translate things, site translate things for information purposes, but never for the record. That needs to be translated in writing, okay? And 90+% of the time in court, we're interpreting simultaneously for the limited English speaking defendant. Only when there's a witness that needs interpreting do we get on the witness stand and we use the consecutive mode. But is the most important mode in the sense that what the interpreter says is what goes on record and what may determine the guilt or innocence of a person. So it's very, very important. more so, of course, than the simultaneous, which is keeping the defendant informed of everything that is said publicly in court, in open court, about him and his case. All right, so this is what I have. I wanted to give, to allow plenty of time for discussion, question and answers. So I'm going to stop sharing here. I'm sorry that I have to go so fast through. These are voluminous manuals. Some of them are more than 1,000 pages. Obviously, nobody reads these cover to cover, but they're such important reference tools for us. Okay, very quickly, in a matter of an hour of preparation, we can really go and cross-check different aspects that relate to the case at hand, and really be very well prepared, not just in vocabulary, because vocabulary is only the superficial part of understanding, but rather in the deeper questions that are coming before the court. The guilt or innocence of a person, their freedom or incarceration, property, life, limb, etc. You know, those things that are so crucial. These are materials to have at hand and to go through them. You know, it's important, you know, even if you have a case, you know what it's about and everything, just go through them and you'll see how you fine-tune your knowledge of what's going on. Not just vocabulary, but a deeper understanding of the process and what each side, the prosecution and the defense, is trying to establish through questions that are usually somewhat veiled or somewhat slanted, in the sense that they don't give you their true purpose head on, unless it's your own witness, right? But rather they do it in a way that is sometimes roundabout, sometimes a little bit hidden, but that we can figure out very easily once we follow a case, the development of the case. And then the other important thing about this deeper understanding is that it makes your interpreting so much easier, because not only can you understand more deeply what's going on, but you can predict what's going to happen, what comes next, and it makes you a lot more relaxed, knowing that you know where you're at, that you know what to do. And so again, I hope that that you get occasion to just use them. Just go online. Some of the ones that I got these recently, so but you can do searches and find, you know, look at a few, find a couple. They tend to repeat a lot of the same things. And again, you can find some specifically from Massachusetts that, you know, it's best to have something from your own jurisdiction. Anyways, that's kind of like the big picture of what I wanted to present, sort of with the philosophy of that it's better to show a person how to fish, you know, than to give him a fish, you know. So I hope that that this will take you to some happy fishing down the line. Thank you so much.